Title 4. Property relations between husband and wife. Chapter 1. General provisions. Include Article 74 to Article 81. Article 74. The property relationships between husband and wife shall be governed in the following order. 1. By marriage settlements executed before the marriage. 2. By the provisions of this code, and 3. By the local custom. Article 75. The future spouses may, in the marriage settlements, agree upon the regime of absolute community, conjugal partnership of gains, complete separation of property, or any other regime. In the absence of a marriage settlement, or when the regime agreed upon is void, the system of absolute community of property as established in this code shall govern. Article 76. In order that any modification in the marriage settlements may be valid, it must be made before the celebration of the marriage, subject to the provisions of Articles 66, 67, 128, 135 and 136. Article 77. The marriage settlements and any modification thereof shall be in writing, signed by the parties and executed before the celebration of the marriage. They shall not prejudice third persons unless they are registered in the local civil registry where the marriage contract is recorded as well as in the proper registries of properties. Article 78. A minor who according to law may contract marriage may also execute his or her marriage settlements, but they shall be valid only if the persons designated in Article 14 to give consent to the marriage are made parties to the agreement, subject to the provisions of Title 9 of this code. Article 79. For the validity of any marriage settlement executed by a person upon whom a sentence of civil interdiction has been pronounced or who is subject to any other disability, it shall be indispensable for the guardian appointed by a competent court to be made a party thereto. Article 80. In the absence of a contrary stipulation in a marriage settlement, the property relations of the spouses shall be governed by Philippine laws, regardless of the place of the celebration of the marriage and their residence. This rule shall not apply, 1. Where both spouses are aliens, 2. With respect to the extrinsic validity of contracts affecting property not situated in the Philippines and executed in the country where the property is located, and 3. With respect to the extrinsic validity of contracts entered into in the Philippines but affecting property situated in a foreign country whose laws require different formalities for its extrinsic validity. Article 81. Everything stipulated in the settlements or contracts referred to in the preceding articles in consideration of a future marriage, including donations between the prospective spouses made therein, shall be rendered void if the marriage does not take place. However, stipulations that do not depend upon the celebration of the marriages shall be valid. Chapter 2. Donations by reason of marriage. Include Article 82 to Article 87. Article 82. Donations by reason of marriage are those which are made before its celebration, in consideration of the same, and in favor of one or both of the future spouses. Article 83. These donations are governed by the rules on ordinary donations established in Title 3 of Book 3 of the Civil Code, insofar as they are not modified by the following articles. Article 84. If the future spouses agree upon a regime other than the absolute community of property, they cannot donate to each other in their marriage settlements more than 1/5 of their present property. Any excess shall be considered void. Donations of future property shall be governed by the provisions on testamentary succession and the formalities of wills. Article 85. Donations by reason of marriage of property subject to encumbrances shall be valid. In case of foreclosure of the encumbrance and the property is sold for less than the total amount of the obligation secured, the don shall not be liable for the deficiency. If the property is sold for more than the total amount of said obligation, the don shall be entitled to the excess. Article 86. A donation by reason of marriage may be revoked by the donor in the following cases. 1. If the marriage is not celebrated or judicially declared void ab initio except donations made into marriage settlements, which shall be governed by Article 81. 2. When the marriage takes place without the consent of the parents or guardian, as required by law. 3. When the marriage is annulled, and the don acted in bad faith, 4. Upon legal separation, the don being the guilty spouse. 5. If it is with the resolutory condition and the condition is complied with. 6. When the don has committed an act of ingratitude as specified by the provisions of the Civil Code on donations in general. Article 87. Every donation or grant of gratuitous advantage, direct or indirect, between the spouses during the marriage shall be void, except moderate gifts which the spouses may give each other on the occasion of any family rejoicing. The prohibition shall also apply to persons living together as husband and wife without a valid marriage.